This is the video tutorial for trial level briefing. And so we're going to go through several things tonight and then end with a run through of a sample trial brief. So we're going to cover three basic topics: the ethical rules governing trial briefs, motions practice, procedure and audience, and the sections of a trial brief. So with regard to the ethical rules governing briefing, we're going to cover several of those rules just as we did for the letter assignments. And you'll see that there is a general thread that goes through the ethical rules as it applies to the tasks that we perform as lawyers, that we are expected to win on a level playing field, that we are expected to behave honestly and ethically and to win on the merits and to win as the result of good work and good analysis and a meritorious case, rather than on the basis of cheating and subterfuge and things like that. And lawyers can get into a tremendous amount of trouble for not following the rules and can ultimately lose their licenses. And so you'll see that the rules really do not tolerate a lack of transparency, a lack of candor. And so it's incredibly important that in everything that you do, that you behave ethically, that you behave honestly, and that you are above board and not trying to get one over on the court or even opposing counsel. So the ethical rules governing trial briefs, there are four sections that we're going to look at. The first one is the rules that cover our role as advocates. The next is transactions with persons other than clients. Next is law firms and associations, meaning your role within an organization. And then finally, maintaining the integrity of the profession. What you'll see is that it's really never anybody else's fault if you get in trouble. You really can't blame it on other people. As a lawyer, really the buck stops with you. So Rule 3.1, this is one that we looked at when we talked about letters, that a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein, unless there is a basis in law and fact for doing so that is not frivolous. So every claim that you bring, every motion that you file, everything that you do has got to be done with a basis in law and fact. You cannot assert a defense. You cannot file a claim. You cannot make a request to the court that is frivolous or for any purpose other than to actually get to the bottom of the dispute between the parties and how that best needs to be resolved. Notice that it relates to not only to asserting legal claims, but also material factual statements that are false, as you see in 3.1b3 at the bottom of the slide there. And so you've got to have integrity with regard to the facts. We're going to talk about the facts for the next two classes and about the different ways that you can construct your narrative for the client. And I want to be sure that what we're talking about is putting together a story that best supports your client. We're not ever talking about lying. We're not talking about fudging the facts. We're not talking about spinning the facts. The truth of the matter is that with any given set of facts, you can tell a number of different stories, and you are obligated to zealously advocate for your client, which means you have an obligation to construct a narrative that supports your client's claim, but that doesn't mean that you can cross the line and submit material false statements of fact. Delay of litigation. You shall not use means that have no substantial purpose other than to delay or prolong the proceeding. So again, every request that you make, every document that you file has got to have a basis in law and fact. You can't simply file them for the purpose of delay, either to run up the expenses on the opposing party, to hide your own lack of preparation, or to run up your client's bill. Rule 3.3, conduct before a tribunal. Basically, this says things that the other rules have already alluded to or said directly, which is that you cannot make a false statement of law or fact to a tribunal, nor can you fail to correct a false statement of material fact or law that you may have previously made unknowingly. But in addition, look at sub A2. You also shall not knowingly fail to disclose to the tribunal controlling legal authority known to you to be directly adverse to the position of the client and not disclosed by opposing counsel. This means if you find law, a case, a statute, a regulation, an interpretation, if you find directly adverse authority to your client's position, you have to disclose that, particularly if the opposing counsel does not. And so this just reinforces the idea that our primary role is our primary obligation and our primary loyalty is to the system, not to the client. Our obligation is second to the client, but first and foremost, our obligation is to maintain the integrity and efficiency of the system, which means that we can't try to win by hiding authority that hurts us. From a strategic standpoint, it's just not good strategy either, because eventually all of the controlling authority is going to come out, whether you raise it or not, and you need a strategy that folds that adverse authority within it, that accounts for the adverse authority, and somehow minimizes the damage it can do to your case. And you can't do that if you're just ignoring it. Rule 3.4, fairness to opposing party and counsel. Again, you can't conceal or knowingly fail to disclose that which the lawyer is required by law to reveal. This is especially important with regard to criminal prosecutors. The criminal prosecutors are required under Brady versus Maryland to disclose evidence that tends to exculpate the defendant, meaning information that seems to lead to a conclusion that the defendant is not guilty, that the prosecutor has in their position, has got to be turned over to the defense attorney. Failing to do that can ultimately invalidate a conviction. And under these ethical rules, the rules of professional responsibility, it can also get the prosecutor individually in some hot water with the bar. And there are prosecutors who have lost their licenses over things like this. So again, you see the thread over and over again that the goal is to win fairly. The goal is to behave with integrity and with an ethical code, and to win on the merits, not to win by cheating or subterfuge. Maintaining and preserving the impartiality of the tribunal. This rule basically says that when you're in the middle of an adversarial proceeding, meaning any case, that you cannot have side discussions with the court or the court personnel about the case itself. Obviously, you can have discussions about scheduling and things like that, but you cannot have ex parte communications about the case itself. And you will see when we look at the document, the sample trial brief, that there's a certificate of service at the end. You are required to give everything that you file with the court to the opposing counsel first, so that the opposing counsel has notice of it. And so you are required to affirm under oath, under your signature, that, or over your signature, that you have served this information to the opposing party and that you have done it in a way that is required by the civil or criminal rules of procedure. Transactions with third parties, truthfulness in statements to others. You're not only required to be candid with your client, candid with the court, and candid with opposing counsel, but anyone that you talk to about the case, you must be candid with them. You cannot make a false statement of fact or law to a third person. That means a witness, that means court personnel, that means anyone. You have to behave ethically at all times. Section 5, law firms and associations. This has to do with the obligations of lawyers as members of the organizations that they work for. Notice that this one, responsibilities of a subordinate lawyer, which is going to become important to you guys in the next few years. A lawyer is bound by these rules, notwithstanding that the lawyer acted at the direction of another person. This means exactly what it says. It means that it will never be a defense to unethical behavior that you were acting at the direction of your boss or that you were acting at the direction of a judge. It doesn't matter who told you to do what you did. You are responsible for your actions. In addition, you are responsible for the actions of the non-lawyers who work for you. 5.3b says a lawyer shall be responsible for conduct of a non-lawyer employed or retained by or associated with the lawyer. That would be a violation of these rules if engaged in by a lawyer. So if they do any of the things that the rules prohibit, if they make a false statement of law or fact, if they hide evidence, if they try to win on your behalf by lies or cheating or subterfuge, you are responsible for that behavior if you knew or had any reason to know that that behavior was going on. And so it's incredibly important whether you are the primary lawyer in a matter or whether you are a subordinate lawyer or a law clerk, that you behave ethically at all times, because you can get not only yourself in trouble, you can get a lot of other people in trouble too. Finally, in Section 8, maintaining the integrity of the profession, this reflects the difference between sort of the organizational loyalties that you might have been familiar with before coming to law school and the organizational loyalties that you'll be expected to observe after you are a lawyer. Your obligation, first and foremost, is to maintain the integrity of the profession. Your first loyalty is to the profession of law and to the judicial system. Your second loyalty is to your client. After that come loyalties to your boss and other people. So it's important then to maintain the integrity of the profession. If your first loyalty is to the profession and not to your boss or your coworkers, the other lawyers that you work with, that means that when you know of people who are violating the rules, you are required. It says a lawyer shall report such knowledge to a tribunal or other authority empowered to investigate or act upon such violation. So anytime you know of someone violating these rules, you're required to report it. Now, this is different than the way we think of loyalty before law school. The way we think of loyalty before law school has to do with personal relationships. For example, in school, we often think of it as sort of the three groups. There's the student, there's the faculty, there's the administration. And students generally tend to be most loyal to one another. And so if you see another student cheating, a lot of students will say, well, I don't want to get involved. I don't want to be a snitch. But that is a concept of loyalty that does not apply in the legal profession. And so in the legal profession, if you see somebody damaging the integrity of the profession, you are expected to report that to the appropriate authority. In law school, obviously, that would be the dean of students. Out in the profession, you can report it to a judge or you can report it to the bar. There are mechanisms for reporting lawyer misconduct. But again, your first loyalty is to the profession. When another lawyer is behaving unethically, that damages your credibility as a lawyer. When other lawyers behave badly, it makes all of us look bad. And so you hurt yourself and the good lawyers by providing safe haven and turning a blind eye to the behavior of the bad lawyers. And the same is true, frankly, of law school, that you damage the reputation of your institution, you damage the reputation of your class as a whole when you allow people to cheat and you turn a blind eye to it. Okay, so the next section, we're going to talk about procedure and audience for trial briefs specifically. So within the realm of motions practice, there are a number of subtopics that we need to cover. First of all is just the general procedure. The first thing that happens in any claim is that a complaint and an answer are filed, or in a criminal claim, an indictment is filed. Excuse me. So once the complaint is filed, the case will be assigned a docket number, and that number is going to have to be on all documents that get filed through the remainder of the case. And so you're going to have to be aware of that docket number and include that docket number on every document that you submit. As soon as the complaint and the answer are filed, motions will begin to follow immediately. They will follow immediately after the complaint. Usually, the first motion filed is filed in conjunction with the answer. A motion to dismiss for failure to state a claim is usually filed with the answer. So once the complaint is filed, the motions start from there. Motions and briefs. A motion is basically a request to the court. It can be oral or it can be written. When a lawyer makes an objection in court, objection, Your Honor, that statement or that question calls for hearsay. That is a motion. That's a request to the court to intervene and require that the other lawyer change whatever he or she is doing. or that the lawyer suppress evidence. Anytime you make a request to a court, that is a motion. Evidentiary motions, or in the course of a trial, are specifically called objections, but they're all motions. A motion can be in writing can be spoken on the record with a court reporter taking notes, or it can be in writing. But it has to be recorded in one of those two ways, either recorded by the court reporter, or it has to be in writing and filed, or else it doesn't count. It may or may not be accompanied by a brief, also called a memorandum. So sometimes what you write, the analytical document that might go with the motion, sometimes it's called a trial brief, sometimes it's called a motion memorandum. It varies from jurisdiction to jurisdiction. In New York State practice, it's generally called a motion memorandum. Sometimes you know in advance that the issue is going to be complex, and so you'll file a brief with your motion. A motion for summary judgment is such a motion. You always know that you're going to need to file an affidavit and briefs with a motion for summary judgment. Motion to dismiss will sometimes be automatically accompanied by a brief. But sometimes you'll file the motion first and then see if the judge wants briefs. And that's the situation that you have in your trial brief assignment, where motions were made, there was a hearing on the motions, and now the judge wants to read briefs on the motions. The judge wants the legal arguments so that the judge has a legal context in which to consider the facts that were obtained from the hearing testimony. So sometimes you'll file it with a brief, sometimes the brief will come later, sometimes you won't ever have a brief. Any motion or brief submitted to the court, like I said, has got to be served on opposing counsel in accordance with the relevant rules of civil or criminal procedure, and that's why you have that certificate of service at the end of the brief. Excuse me. Again, you may not have ex parte communications with the judge, and so anything that you file with the court, you have to give a copy to opposing counsel in a timely manner. Once you have filed a motion, there may be a hearing either before or after a brief has been filed. The hearings tend to be less formal in state court than in federal court. In state court, you may have them in open court with both attorneys at counsel tables, but you may be seated as you talk to the judge, or you may be just standing at the bench. As a general rule, in federal court, you don't open your mouth unless you're standing up. In some state courts, judges prefer to run things that way. That's a more formal way of running their courts. But in state courts, things tend to be a bit less formal than they do in federal court. But in federal court, if you're going to have a hearing on a motion, you're going to be standing behind a podium, arguing to the judge one at a time. It won't be a conversation. In state court, sometimes you can have the discussions in chambers or in open court, and sometimes it doesn't really look like a formal argument to the court. Sometimes it just looks like a conversation. And for example, I showed you guys last semester, at the beginning of the semester, a clip from Law and Order where the opposing attorneys and the judge were having a conversation about a particular legal issue. That was a motion hearing. It was just the three of them having a conversation in chambers, and that was a formal motion argument. You should always get your hearings, your motion, your brief, and your hearings on the record. So that means everything needs to be in writing or transcribed by the court reporter in case you need it later for an appeal. And we'll talk later when we talk about appellate briefs about the fact that you can't bring something in the appellate court that you haven't gotten on the record in trial court. The audience for a motion is going to be a trial judge, primarily. We're talking primarily about trial motions. There are appellate motions that we'll talk about, but the vast majority of motions practice is a trial practice. So remember that the primary purpose of a trial is to determine the issues of fact, and either the judge or the jury may determine those issues. So the role of the trial judge is to decide issues of fact, if you don't have a jury, if you have a bench trial instead, to decide issues of law, and to instruct the jury on the law. The juries will determine facts if you've got a jury trial, and then arrive at a decision using the judge's instructions on the law. So the legal issues are confined to just what is necessary to instruct the jury on the law, or what the trial judge needs to resolve motions as the case progresses. Trial judges are very reluctant to make new law. Remember when we talked about the hierarchy of authority and the different rules of the different courts, that the trial court's primary function is to resolve the factual issues, and the appellate court's functions are to resolve issues of law. Specifically, the highest court of last resort in any system is primarily charged with changing the law or confirming the law or resolving splits in the law. But trial judges are very reluctant to make new law. And so claims based on an extension or a change in the law usually won't go very far in the trial court, but if you want to make them in the appellate court, you have to first make them in the trial court. But keep in mind that trial judges generally don't want to make the new law. You're generally not going to get very far on a novel claim in the trial court. You usually won't get anywhere with that until you get to the appellate court. Heavy dockets at the trial court level. Remember, there are so many trial courts as compared to the number of appellate courts. And those heavy dockets mean that trial judges are very busy readers, and they may rely more on law secretaries, clerks, and interns. In addition, you have a lot more latitude when you are drafting a trial motion or a trial brief, because there generally don't tend to be the same strict formatting rules with regard to motions and briefs that you see in appellate courts. And so you have a little more latitude in trial courts in formatting your documents. And we'll talk in a couple of weeks about the best possible way to format the document to facilitate comprehension by a busy reader like a judge. Types of motions. There are a lot of motions because the primary function of the trial court is to resolve issues of fact. There are several kinds of motions that seek to dispose of cases that have no fact issues. One of those is a motion to dismiss. And so you might file a motion as a defendant and say there is no claim upon which relief can be granted. And the material facts are not at issue. And so because there's no fact issue and because the law is well settled, there's nothing for a court to do here. So you'd file a motion to dismiss. Likewise, motion for summary judgment. After you have gone through the process of discovery, if it turns out that you believe that the material facts are not in dispute, you might file a motion for summary judgment and say, listen, there's no factual issues for a jury to determine here. And so there's nothing for a jury to do. Therefore, court, you can just decide this case based on the law right now. Other motions, the vast majority of motions, seek to ensure that proper procedure and evidence were used in arriving at the final decision. And so a motion to quash an indictment, to quash a subpoena, things like that. A motion to suppress evidence. A motion for judgment notwithstanding the verdict. If you believe that the verdict is not supported by the evidence, then you might file that kind of motion. But there are opportunities for motions from the very beginning of an action all the way through until the final appellate court disposes of it. Anytime you want to ask the judge for something, you do that through a motion. Okay, so now we're going to turn to specifically the sections of a trial brief. Remember that the basic theme of the analytical documents that we have covered so far is that all documents have basically the same information in the same order. There's a heading of some kind, an identification of the issue, an answer to the issue, a statement of the relevant facts, legal analysis that follows a CREAC format, conclusion, and we see that with all of the documents that we've handled. And so the memo, looking down this first column, was an evaluative document, and it had that memo heading, and then the question presented, the short answer, the statement of facts, discussion, and conclusion. The letter, which was also an evaluative document, had the same type of information in the same order. It was just retooled for a lay audience rather than a legal audience. So like you had the heading in the memo, you've got the letterhead and the addressee's address and the subject line for the letter. Just like you had question presented and short answer in the memo, you've got that intro paragraph for the letter that serves the same function. Likewise, you've got paragraphs of facts for your statement of facts. Discussion, you've got a legal analysis. It's a very simplified legal analysis, but it nonetheless follows the same basic format. It starts with the rule and then shows how the rule would be applied by both parties, since it's an evaluative document. And then finally, you get to a recommendation paragraph, which is similar to the conclusion in a evaluative memorandum. The thing that the letter has that the memo does not is a closing and signature, and so that is unique to the letter. And now that we're moving into the trial brief, you'll see that the trial brief also has the same types of sections. For the heading, it has a court caption, which will give the identification of the court, the docket number, as well as the name of the case. Instead of a question presented in a short answer, there will be an introduction section, and it will be a single paragraph that will tell the reader what the issue is, what relief that you want, and what is your legal basis for the relief that you want. But it serves the same function. It identifies the issue and it gives your answer to the issue and tells briefly why you think that you're correct. Next is a fact section. It can also be called a statement of facts if you like, but we're going to call it just facts, where you give the facts. Now this time, because we're working with a persuasive document rather than an evaluative document, we're going to be writing a persuasive fact statement. And we will talk over the next 2 classes about how to do that, about how a persuasive fact statement differs from an evaluative factual statement. The next section is the argument, which is the persuasive version of the discussion. You already know how to write the basic bones of an argument. It still follows a CREAC structure. You still can use consecutive and clustered organization within each issue. There are going to be some differences between persuasive and evaluative analysis. Obviously, you're not going to give the opposing party's position. But other than that, the basic structure is the same. And so that's why you can already be thinking about what the structure of your argument is going to be, even though we're not going to talk about it for another week. The final section in the trial brief is called the prayer. It serves the same function as the conclusion. You restate what relief that you want, what it is that you want from the court, and why you think you're entitled to that relief. And then at the end, similar to a letter, you've got a signature block and a certificate of service. The signature block affirms that the document that you're filing is not frivolous, and the certificate of service affirms that you have shared this information with opposing counsel prior to filing it with the court, and that you have served it according to the requirements of the rules of civil or criminal procedure. So again, we've now had 3 different types of documents, 3 different audiences. The memo is an internal audience within your office. The letter is external, being the client, but still evaluative. And the trial brief, the primary audience, is a judge. And so while they differ somewhat because of the audiences and the functions that they serve, they still have the same basic types of information in the same basic order, which means that anytime you're faced with a new document to draft that you may not be familiar with, you can always start with this basic framework that you're going to have a heading, an issue and answer, statement of facts, some sort of discussion or argument, and then some sort of conclusion. And so you always know that you can start with that basic structure. For the trial brief, obviously we don't need to talk about the entire thing from start to finish because you've already had experience with drafting a heading, with drafting issues and answers. You just need to be able to modify it for this particular context, which you'll see in the next segment of this video. The statement of facts. We've talked about how to write an evaluative statement of facts. We'll talk about how to adapt that for persuasion. But you already know that what you need to include is the legally relevant facts along with the contextual facts. Prayer, likewise. This is different in that you're going to remind the reader, who is the judge, what it is you want the judge to do. But then other than that, you're going to summarize basically why it is that you think your conclusion is correct. And then finally, the difference in documents filed with the court is that you have to affirm by your signature that you have done all of those things that the ethical rules require of you, that you have not misrepresented the law or the facts, that you haven't, that you're not filing this without letting the opposing attorney know about it. And so while each one is a slight variation, they're all the same basic structure. It's all the same bones. Okay, so the next segment will be the video that walks you through the trial brief.